So the Supreme Court denied a stay that would have protected a state's Second Amendment sanctuary law that they put in place for their state residents. So let's talk about what is going on. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again uphold our right to keep and bear arms, go ahead and hit that like button and subscribe. Also want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like FPC and GOA, so if you want to support the 2A cause, I highly recommend Blackout Coffee. You can check them out using the links down below, and if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, in this video, we're going to be talking about an order that was issued by the Supreme Court and how it's having a drastic impact on a state's Second Amendment sanctuary law. The recent Supreme Court order denied a stay which would have protected Missouri's Second Amendment Preservation Act. Now, in response to this state Second Amendment sanctuary law, the United States government sued Missouri. Of course, the federal government did not want this in place. Recently, the Supreme Court got involved in this case and denied a stay which would have allowed the state to continue to enforce the law, at least while this was making its way through the appeals process in the 8th Circuit. However, I will say that despite what the Supreme Court recently did in denying those protections, the state of Missouri is not giving up. They are still trying to fast track this review through the 8th Circuit. But this decision by the Supreme Court is having some negative ramifications, and there was a lot of things that were warned of, and in fact, Justice Thomas potentially was even concerned with this, and it's now playing out because of what the Supreme Court did. Now, you may be curious about what are all the intricacies with this specific law. Missouri passed the Second Amendment Preservation Act through HB 85. The act declares that federal supremacy does not apply to federal laws that restrict or prohibit the manufacture, ownership, and use of firearms, firearms accessories, or ammunition within the state because such laws exceed the scope of federal government's authority, and therefore Missouri is not giving funding and they're not going to help support these types of inconsistent federal laws that violate the Second Amendment. Now, at its core, this law uses the 10th Amendment to deny state resources to unconstitutional federal actions. Essentially, this law allows any person in Missouri to sue a state agent or employee who tries to enforce a federal law that infringes on the right to keep and bear arms. This Missouri law is essentially similar to what Texas did with their abortion law and the recent Supreme Court decision in the whole women's health case. That fact is also important to why the whole women's health decision was referenced by Justice Alito in the recent order that was issued in this Missouri case when it got its way up to the Supreme Court. Now, if you're not aware, the Texas abortion law that I'm referencing is SB 8, which prohibits an abortion if a fetal heartbeat is present. The law is different from other laws because it is not enforced by the state of Texas or any of its executives or its attorney general, but rather it allows an individual, the residents, to sue any other individual who performs or knowingly aids and abets in that activity. This means that the enforcement mechanism and the one enforcing the law is not the state of Texas. Instead, any person who wants to sue can sue to stop that conduct, and the power is kind of left to the people to file these lawsuits. Here's where things become relevant for Missouri's Second Amendment Preservation Act and the recent Supreme Court denial in this case. SB 8 shielded Texas and officials from lawsuits since the statute allows only individuals to bring a lawsuit, not the state or any of its officials. The enforcement mechanism, again, was designed in a way to be in the hands completely of the people, not the state itself. Now, the Supreme Court on review found that since this Texas law, SB 8, is not enforced by the state or its agents, then you cannot seek an injunction against them. You also couldn't even get an injunction against the judges or the clerks who were part of these lawsuits that were filed by the private individuals, by the residents who were filing these civil lawsuits. You couldn't even get an injunction against those judges or those clerks and stop these lawsuits from happening because, again, they are not actually the ones who are part of these lawsuits. That's not how this law is structured. So that is kind of the backdrop of how Missouri is doing some of these things. Missouri, and this law was passed before those, but it's a similar structure. And then this whole women's health decision by the Supreme Court is also referenced and plays into what happened with the Supreme Court. The state of Missouri removed themselves from enforcing this law and instead, again, gave the power to the citizens to file these lawsuits. Now, of course, Missouri did not like that. They don't like this law being in place. They don't like any language that says that they're violations of the Second Amendment, these federal laws. They don't like that they are being opposed, so they filed a lawsuit against the state of Missouri. And a federal district court on review struck down the entire Missouri law and enjoined the state of Missouri and its officials from enforcing these laws. But again, here is the issue in this case. None of those state officials are the ones who are actually enforcing any of this. Missouri then appealed the decision up to the 8th Circuit and also asked for a temporary stay of the decision of the lower court, the district court, while the appeal is making its way through the process. However, the 8th Circuit ultimately decided to deny that temporary stay. And then what Missouri had to do is the state filed an emergency application for Supreme Court intervention and for the Supreme Court to grant an emergency stay in this case. The issue was that because of what happened in this case, the Second Amendment Preservation Act, this aspect of the law, had been in place for a long time. It was the status quo, and that's kind of just been the law in Missouri since it was passed. And so all of these decisions by the federal court and the denial of the stay by the 8th Circuit would change a lot of that. So what Missouri was asking for the Supreme Court to do is simply to maintain the status quo, at least temporarily, and to grant a stay. Well, we got an order from the Supreme Court, and what they decided to do was deny the stay. In an 8-1 decision, the order states, the application for stay presented to Justice Kavanaugh and by him referred to the court is denied. Justice Thomas would grant the application for stay. So it was an 8-1 decision. The only dissenting judge was Justice Thomas, and Justice Thomas would have granted the state of Missouri their stay to protect the Second Amendment Preservation Act within the state. Now, there was a statement from Justice Gorsuch and Justice Alito. They added some additional language for why they joined the majority in not granting the state of Missouri their stay. And it's interesting because their position is that even if they granted the stay, it really doesn't change anything, and their denial of the stay, in their opinion, doesn't change anything, again, because of the whole enforcement mechanism of what's going on in this case. They state that with the understanding that the district court prohibited only implementation and enforcement of HB 85 by the state of Missouri and its officers, agents, and employees, and any others in active concert with such individuals, I agree with the denial of the application for a stay under the present circumstances. An injunction purporting to bind private parties not before the district court or the challenge provisions themselves, however, would be inconsistent with the equitable powers of federal courts. And there, directly, he is referencing and cites to the whole women's health decision, which I just brought up, which is that Texas law. Now, the goal of this was to get the Supreme Court to grant that stay, but only Justice Thomas was the one in favor of granting the state of Missouri's stay. But even after this order, the state of Missouri has responded quick by trying to expedite review of this case in the 8th Circuit. So they filed for emergency expedited review of this case because of what the Supreme Court said, because of the potential status quo changes of what happened with the Supreme Court denying of the stay and the opening of the door and the injunction being potentially in effect, even though the injunction only impacts the state of Missouri and its employees, but it still opens the door and still changes the status quo within the state. So the state of Missouri wants expedited review of this case in the 8th Circuit. And they asked for expedited review and they filed for that back on October 23rd. Now, what's interesting is the 8th Circuit has taken absolutely no action on the expedited review request. They haven't filed for additional briefings. They haven't requested additional briefings. And in fact, they've taken so long to respond to this that the attorney of record for the state of Missouri is no longer even attorney of record. In fact, he recently filed a notice to the 8th Circuit that notified the 8th Circuit that he's no longer the attorney of record for Missouri, so they're going to have to get a new attorney of record. And so that's kind of how long they've lagged on this issue, even though expedited review is being requested. So the denial by the Supreme Court, that 8-1 decision, still has some ramifications. I know that Justice Alito and Justice Gorsuch were stating that they're not that concerned about it, but I think Justice Thomas, like I think everybody in the Second Amendment world, agrees that Justice Thomas was correct. There were going to be ramifications, and the fact that the 8th Circuit is absolutely slow walking and slow playing the review, even though it's been requested for expedited review, the fact that they're slow walking that shows that there are real ramifications for when the Supreme Court decides to not act on these issues. And right now, we're also going to potentially be facing that when it comes to what's going on in Illinois with their ban on rifles and magazines. There are multiple cases that are asking for emergency review from the Supreme Court for the Supreme Court to step in and halt some of those laws, at least on a temporary basis. And the question is the Supreme Court going to step in? I would suspect that they aren't, because the Supreme Court has been very inactive when it comes to these issues right now. They don't want to step in on an emergency basis. They don't want to step in early. But again, all of those decisions, like here in Missouri, have ramifications, and it leads to a lot of these circuit courts then slow walking these cases after the fact. So again, this is still a really interesting case. I know a lot of people in Missouri and other states are really interested in this case. If we get more information, if anything else develops, of course, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So again, thank you guys so much for all of your support. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.